Good morning, one and all. This is Divya, Assistant Professor, Bharat Institute of Law. In this video lecture, I'm going to discuss about the labor legislation in India. In this session, I'll be discussing about how labor legislation has been taken place in India during the period of British colonialism and after independence. And also, I'll be discussing what is an organized and unorganized sector, what is the relationship between a master and a servant, and at the end of the session, I'll be discussing about the theory of laissez-faire, along with its components, advantages, and disadvantages. Now let's move on to the first slide. So labor legislation has been taken place in India during the period of British colonialism. The first and foremost objective and the purpose of labor legislation is to find the relationship between the employer and the employees. So unless we know what is the relationship between the employer and employee, it will be very difficult for us to define what is their rights and what is their bounded duties. So the main objective of labor legislation is to find the relationship between the employers and the employees. Since before the British colonialism, that is British invasion into India, all the laborers are handled and treated as slaves in India. But after British invasion into India, they brought many enactments regarding laborers. They gave various laws which gives various welfare measures and rights for the laborers. So the British government gave the laws which is very attractive and which is very helpful for the laborers. So some of the laws which is very helpful for the laborers are they have defined the working condition, that is how many hours they have to work and what is their time of working, and for a week how they will be getting salary and what is their shift. So these are the kinds these are the working conditions that they have been mentioned in their act. And also they have given certain extra welfare measures for the women and children who are all working in the factory. And women were given certain relaxation in their workplace, like maternity relief and so on. So these are all the main welfare measures that has been brought during the period of British colonialism. And after independence, if we see, in our Indian constitution, they have mentioned various enactment which is very helpful for the laborers. So we can see the constitutional relation of labor laws with our Indian constitution. Our Indian government is a federal form of government. So all the powers to enact the labor laws has been given for both the central and the state government. So both the central and the state government will be enacting laws which is helpful for the laborers, which is mentioned in the union list, state list, and the concurrent list. So we shall move on to the next slide to explain about the constitutional relation of labor laws, constitutional relation with labor laws. So in part 3 of the Constitution of India, which says about the fundamental rights, in certain articles, our Indian Constitution have mentioned the rights for the laborers. We shall see some of the articles which has been mentioned in part 3 of the Constitution. So Article 14 explains the equality before law. So every person has to be treated equally, whatever their wage, or if they are being paid, or if they are being given an opportunity for an employment, every person has to be treated equally. In a case law called the Ranveer Singh versus Union of India, the Supreme Court held that equal pay must be given for the equal work. So if two persons who are working in the same employment and same kind of work, if the nature is very same, they have to be paid equally. So this is what they have interpreted in this article. And next is Article 16, which says about the equality of opportunity. That is, every person has to be treated equally, apart from the discrimination regarding their gender, caste, community, creed, and so on. So every person has to be given equal kind of opportunity. And next is Article 19(1)(c), which says that right to form an association. That is, this has been implemented in the Trade Union Act, which says that any person can make any union in a factory, So it is called as trade unions. So this trade union is very helpful for the laborers for the purpose of collective bargaining. That if any person, if any individual person or if any group of person have any issues with the management, or if they have any demand or need from the management, they can collectively bargain the same with the employers. So it will be very helpful for them to talk or negotiate with the management. So this has been implemented in the Trade Union Act 1926. And next is Article 23, which says that prohibition of forced labor. That is, no one shall be forced to do some labor thing and without paying any wages, or like with paying very minimum amount or the lowest amount of wage. So that kind of act should not be done. So here in a case, it has been interpreted that by using their weaknesses, we should not force any person to do a labor thing without paying a proper wage. And the wage related thing has been implemented in the Minimum Wage Act, which says that every employment have certain amount of minimum wage which has been fixed by our government. So the employment, so in what sort of employment the minimum wage is fixed has to be paid by the employer to the employees. And next is Article 24, which says about the prohibition of child labor. So any child who's under 14 years of age shall not be allowed to work in any kind of employment. So this is explained in Article 24. And in Part 4 of the Constitution of India, which says that it is under the directive principles of state policy. It also gave certain articles which is very helpful for enacting labor laws. So I've mentioned some of them here. So Article 38(1), which says that to promote the welfare of a people, so every person's welfare must be promoted to a greater extent. And next is Article 38(2), which says that there must not be any inequalities in the payment of wages to the people based upon their working place, or it depends upon whether they are urban or from rural. So there should not be any discrimination in the payment of wages. And next is Article 39(a), which says about adequate means of livelihood. That is, a person must be paid which based upon their need. That is, minimum wage is fixed by the government based upon the cost of living index of an individual person. So the same has to be paid to the employees. And next is Article 39(d), which says that equal pay for equal work. And next is Article 41, which says that right to work. And next is Article 42, maternity relief. That is a relaxation given to the women workers in the workplace. And next is Article 43, which says that living wage for workers. So it is same as that of the minimum wage that has to be paid to the employees. And next is law relating to. So these are all the 5 categories in which all the labor laws can be brought into. So normally labor law is not just a single act, but it is a collection or a consolidation of various acts. So all the labor laws can be brought into these 5 categories. I'll explain what are all the categories. So first thing is the law relating to wages. So any law which represent how much amount has to be paid to the employees and in what mode they have to pay the payment, and if the employer is making certain deduction in the wage, so in what basis they can make that deduction. So all these things can be explained only in these laws which is related to wages. And next is the law relating to social security, that is giving some welfare measures to the employees, like Employees Provident Fund Act, which says that after their retirement, they'll be getting certain benefits. So these are all like giving certain benefits to the employees. So such acts are called as social security, law relating to social security. And next is the working hours, conditions of service and employment, that is it says about the working condition of employee, that when at what time he has to come for work and what time he can leave the work, and what is the shift basis, and in what kind of employment he is doing, what is the nature of his work. So everything will be explained, and when he can take leave. So all these sort of informations will be given to the employee. So these things are mentioned in certain acts. For example, in Factories Act, they have mentioned certain things. And next is equality and empowerment of women and children, which says which gave welfare measures and benefits, safety related measures, and certain relaxation to the women and children, that for children only certain kind of work must be given, and it should not be like equal kind of work which has been given to an adult man, but and also certain kind of relief for the women, like maternity relief. So these acts will be coming under this category. And next is the prohibitive labor laws. So prohibitive is, that is, if you are doing certain thing, it is an offensive thing will be coming under this prohibitive labor laws. That is, like child labor is being prohibited and bonded labor is being prohibited. So these are all prohibitive labor laws. So these are all the 5 categories under which the labor laws can be classified. So this is the constitutional relation and the law relating to. So these things we have seen. And next, we are going to see about what is an organized sector and what is an unorganized sector. So an organized, first I'll be explaining what is an organized sector. So organized sector is a sector in which the laborers will be having a regular work and an assured work. That is, there is no fear of losing their job easily. So it is an assured kind of work. So the best example of an assured kind of work and a regular basis work is called the contract based works. So if there is any contract between the employer and the employee, then such kind of work can be called as organized work, assured work. And so these organized sectors will be mostly registered under the government. And this that is what I've given in my second point. And third point is that the work will be in regular basis, so the wages will also be fixed in rate. So the wages, like for example, if they make a contract, if there is a contract between the employer and employee saying that for every month you'll be paid or 20,000 rupee or 30,000 whatsoever, so that amount will be in a fixed rate. So there won't be any unnecessary deductions or some other things. So the work, based upon their work, they'll be paid every month. And also they'll be having increments or allowances other than this regular wages. So for example, like after working here for 1 year, you'll be getting an increment of 5,000 rupees. So this sort of agreements will be there. So they'll get certain increments and allowances like house rent allowances, travel allowances, food allowances, like that. Some sort of allowances will be given for them apart from the wages. And the next thing is they may be given certain kind of bonuses from the profit. So these are all some of the merits in an organized sector, which we cannot see in an unorganized sector. And next thing is they can form a trade unions, as it is an assured and regular basis work and it is being registered under the government. They have the right to form a trade union, so that because of this trade union, they have the right to collective bargain. So this is one additional privilege or immunity that has been given to the employees. So this is also one sort of merit. And next is the fixed hours of working, that from morning 9 to 4 or like some sort of fixed hours of working will be given here, but which is an opposite thing of an unorganized sector. So in an unorganized sector, there is no assurance for the work. So this sort of works are mainly seasonal in character. That is, for this sort of season or only in these months they'll be having job. For example, agricultural laborers. So during the plantation time only they'll be having work, not in all the other months. So these sorts of work, and also further examples like fishermen's, and so these sorts of works are seasonal in character. So only in that month, like they will not be having work for the whole 365 days, but only in 3 months, that is a 90-day or 100 days they will be having work. So this sort of unorganized sector cannot be registered under the government. So there is no regular kind of work. So the wages cannot be fixed by the government to these sectors. And also there is no increments, as the wages cannot be fixed. There is no increments also, no increments or allowances or bonus also, there won't be anything. So it is not like a regular basis of work. There cannot they cannot form a trade unions, as the employees is not meeting every day, or they cannot meet the employer also the every day. So there is no formation of trade unions, and the working hours is also not fixed, because the working time is depends upon the nature of the work. For example, in agricultural thing, they may have work in the early morning, or only in that period of time, like in the early morning from our for 3 hours they may have work, and the other time they may not have work, so they cannot fix the work. So it mostly depends upon the climatic condition or the need, and also for the every year they may get job, so such kind of assurance will not be given, like every year in these 3 months you will be having work, so such kind of assurance will also be not given because of natural calamities or some other external forces. So this is an organized sector. So the labor laws are applicable only to the organized sector and not the unorganized sector. So before going into what is labor law and what is the laws given by, what is the laws enacted, we have to understand to whom it is applicable. So only understanding the applicability of this laws, we can apply in any situation. So that's why I've explained this in the first thing. So in organized sectors, the work is assured and it is registered under the government, and also they can form trade unions. So only in these sorts of sectors, the labor laws are applicable. Okay. So next we shall see what is the relationship between a master and a servant. So this is also a very important topic that you have to understand before going into what is labor law and what is the laws exactly, which is exactly mentioned in any act. So before going into law, we have to see what is the applicability, right? So first we have seen that it has to be applied, it can be applied only in the organized sector. Next, we have to understand to whom, to the person, whether he is an actual employer, whether he is an actual employee. So this thing we have to understand first. So I've brought this concept here. So the master and servant relationship, we have to find whether there is a master and servant relationship between these two persons to apply all these labor laws. So a master and a servant has some sort of relation where one person will be guiding or instructing or giving command to do something to the other person. So the other person, that is the servant, will be doing a certain act which has been instructed by the master. And for doing such act, that person will be paid some remuneration or some consideration. So there must be this sort of relationship between them. So only in such circumstances, they will be called as master and servant. And there is also some other kinds of person who is working for another person, but they will not be coming under this master and servant relation. So who are they is, first is an agent and second is an independent contractor. So these persons will not be called as servant, because an agent is a person who is working for another person. He's not working for another person, but he's working on behalf of another person. So he's working as an agent, not for the agent. So agent is not called as a servant. And next is an independent contractor. So independent contractor is a person who is working for another person, but he will not be he will not be instructed by the master. Each and everything will not be instructed by the master, but he only gets a contract or something from another person. But everything, the way in which he is going to finish the act, that is finish the contract, only depends upon the independent contractor and not on the servant. So every instruction will not be given by the servant. So this person will also not be called as a servant. So these two people is not a servant. Only the person who has been working for another person with all by following all the instruction given by the another person and getting certain kind of remuneration is called as servant. So only these sorts of relation will be called as employer and employee. So the labor laws will be applicable only to these kinds of relationship and not any other. Okay. So next we shall see the theory of laissez-faire. So this is the theory of laissez-faire is a phrase which has been taken from a French which says that leave us alone. So leave us alone means in this they have mentioned that the government must leave the market alone. So to work on its own. So this is what they are mentioning here. So naturally in a country or in a market basis, if we see, everything will be controlled by the government, that they have to, if I want to create, or if I want to start a business, or if I'm willing to register a factory, first I have to get permission from the government saying that, so these kind of manufacturing things I'm going to do, and these sorts of labors I'm going to employ, and what kind of manufacturing process, and based for this manufacturing process I'll be using all these sorts of raw materials, and I'll be using this amount of electricity or some other resource, whatever. So I'll be using all this. So everything must be informed to the government, and I must get certain a permission, and the government will be giving me the registration certificate as well as a license to do this sort of manufacturing process. And that license also has to be renewed periodically. For example, for 3 years, once in 3 years, or once in 5 years, and so on. So every process, and for such registration or for renewal of a license, there is a lengthy procedure. There is certain rules and regulations that I must follow. So this is very hectic in nature. So this theory says that the government intervention in the market must be very less, so that every person will have certain interest, or they may have certain willing to do some business, and every person may have some innovative ideas, but because of all these restrictions, they will be restraining themselves from doing that business. So this policy say that the government has to must not interfere more into the market, and it has to leave the same to the market needs. That is, based upon the demand, the supply will be there. So based upon the necessities of the people, the supply can be there, and the government cannot need not interfere into the market. So this sort of policy and this sort of society is called as a capitalistic society, which is just an opposite of socialistic society. So, so the second point I mentioned here is to promote the free and the competitive market. And the free movement of forces will be there, and it is mainly based upon the demand and supply in the society. So there is no unnecessary need for the government to interfere into everything, every function of a person and a business. So next the slide says, okay, next is the components of a laissez-faire policy. So first is, it is a capitalism, that is, I've mentioned that it is a capitalistic society where the government intervention is very low. Next is free market economy. That is, if a person is willing to, like, if I'm doing a business, I'm having a factory and I'm manufacturing certain kind of product, and I'll be fixing the rate of the product in a rate depending upon the expenditure which I've sent to produce this product, as well as if I want certain kind of profit, I'll be adding that also. So expenditure plus the profit I'm willing to take. So this is the way I'll be fixing the price of a product. So normally in a free market economy, the price will be fixed by the producer and not by any other third person, that is the government. The government will not be fixing the price of my product, but I will be fixing. This is very helpful and very motivating for the businessman to do some innovative things in the market. So this is what the second thing, that is free market economy. So every product, it depends upon the necessity. The product will be produced. That is, depends upon the demand. The product, the supply will be there, and the price will also be fixed based upon that. And next is the rational market. That is, every decision that has been taken in the market is fully based upon logic and based upon and not based upon the emotional thing. That is, if I'm the producer, I'll be fixing the price of my product to a certain thing, like based upon the logic. What is my expenditure? I'll have the full knowledge about the product, about the production process, and I'll be fixing the price of the product depend upon that. But in kind of, if the government is doing fixing certain price, so the government will be mainly having in mind regarding the need of the citizen and what is their purchasing power. So these are all like sentimental basis and not logic in base. So the rational market is everything, every decision that has been taken in the market should be based upon the logic and should not be based upon the sentimental or some other thing. So next is the government intervention will not be eliminated to the extreme thing, will not be eliminated wholly, but in certain exemptional situations, the government can interfere into the market. What is it? Is protection. In order to protect any person, that is, if any individual person or a group of persons' right has been infringed by any other person in a wrong way, that is against morality or by affecting something, in only in that sort of situations the government can interfere. And next is, while if any action that has been taken place against antitrust in an antitrust case, I'll explain what is antitrust laws. So antitrust law is anti-competitive agreements. That is, if any two person enters into an agreement which is effective in nature to the market or any other person in the market, then that is called as anti-competitive agreements. I'll be giving an illustration for that. For this, if, for example, there is a 100% market. In that, 40% of the shares, or it is not a share, actually 40% of the market is held by one person. For example, we can say as A. If 40% of the market is held by A and 20% of the market is held by B. So the remaining 40% is held with any other small brands and many small brands. So in this sort of market, if the first 2%, that is the person who is holding 40% in the market and the person who is holding 20% of the market are tying up to eliminate all other persons to enter into the market or to eliminate them from the market, if they are making an agreement between them, then that sort of agreement can be called as anti-competitive agreements. That what will happen is all the other 40% will be eliminated from the market. So this 2% will be entirely ruling over the market. So what will happen is the customer will have no right to choose between the brands, choose between the products. So this would eventually, what will happen is an adverse kind of effect will be taken. For example, how the effect will be is, the price of the product will be gradually increasing and the quality of the product will be gradually decreasing. So this is what the effect would be, and it also would be affecting the customers. So this sorts of agreements has to be eliminated. And the same is cartel. And next is abuse of dominant position. That is, if any person, that is, if any brand is being in a dominating position in the market, that person will be doing some act in order to curb another person to enter into the market. If such act has been taken place, that can be eliminated or that can be punished by the government. Next is combination, that is merging, accusation and combination. That is, if any two person with ill intention to eliminate any other person or to restrain any other person to enter into the market, if they are doing certain merging, some sort of things like merging their company, that is called as antitrust laws. And the last is predatory pricing. So predatory pricing means fixing the price of the product in a very low rate. I'll say an illustration for this. That is, for example, if a pen can be made at a rate of 10 rupees, for example, the expenditure of making a pen is 10 rupees. So the pen, the same pen can be sold at from the age of 10. From the rate of 10, that is, it can be sold at a rate of 10 or 11 or 12 by keeping certain profit. But it cannot be sold at a rate of 5 rupees, right? So this, if a person is fixing a pen which is worth of 10 rupees to the rate of 5 rupees means, then that is called as predatory pricing. That is, this would eliminate all the other person from the market, that all the customers would be like to buy this predatory priced product. Normally, all the other brands would be facing a heavy loss, which would restrain them from to enter into the market. So this is called as predatory pricing. And next is advantages of laissez-faire. So advantages, if we see, the first thing is autonomy. That is, the person will be having independent and there will be certain sort of freedom to enter into the market. And the next thing is innovation. There may be many innovating ideas for every person to enter into the market. So this will be very helpful. And the third thing is absence of taxes. So and the next thing is absence of taxes. So the government intervention is very low and there is no need for paying more taxes. And the major disadvantages of this policy is income inequality. So any person who is investing and doing good in the business will be earning more, and because of which the resource in the country will be held by certain hands and all other person will be facing poverty. So in general, if we see, while if there is government intervention in the market, the government will be imposing taxes in the person who earns in the market, and they'll be distributing all the resources to the needy people also. But if there is no government intervention, then what will happen is there will become inequality in the income in the society. And the next thing is failure to represent the interest of the entire society, that the status of the people will be like certain people will be at the high peak of status and certain will be living in the poverty. So the representing all the people's needs and interests will be very less in this sorts of society. So these are all certain disadvantages of this laissez-faire policy. So thank you.